Good morning. I hereby call this the third meeting of the House Standing Committee on Families and Children to order. As a reminder, please silence all cell phones. Do any members have any guests that they'd like to introduce? Okay, well, thank you all for attending today. We're glad to have you all. DJ, please call the roll.
Representative Bojanowski,
Here.
Representative Callaway,
Present.
Representative Kleins,
Here.
Representative Dietz,
Here.
Representative Doan,
Present.
Representative Duval, Representative Elliott, Representative Holloway, Representative Mosier, Representative Pollock,
Here.
Representative Rayburn, Representative Riley, Representative Rorks,
Here.
Representative Stalker,
Present.
Vice Chair Wilson, Chair Heverin.
Present. Okay, we have three bills for consideration today. First up is House Bill 418, an act relating to domestic violence. Representative Nemes, if you'll make your way to the table with any guests that you may have. If you will introduce yourself for the record, please make sure to hit the push button and the light will turn bright green.
Thank you, Madam Chairwoman. I'm Jason Nemes, District 33. That's Jefferson, Oldham, and Shelby counties. Go ahead and introduce yourself.
Darlene Thomas, Director of Greenhouse 17, Lexington, Kentucky.
Meg Savage, Chief Legal Officer for Zero V.
Okay, we do have a committee sub on House Bill 418. Do I have a motion to adopt proposed House Committee Substitute 1 to House Bill 481? I heard that exact language from Representative Pollock and a second by Representative Riley. Yes. Okay, I'm going to go ahead and say, since we have a motion and a second, we're going to go ahead and pass it, and then we'll talk about what that does. We'll adopt the sub. All in favor say aye. Aye. Any opposed? Okay. We have the committee sub has been adopted. You can go on.
Thank you, Madam Chairwoman. Members of the committee, I want to take this opportunity to, at first, thank you for your work on this bill, and especially Representative Dietz for her work on the bill. She's helped improve it substantially. This bill is about making sure Kentucky family courts treat domestic violence the way it actually affects families, and not as an afterthought. As a threshold, but it's rather a threshold issue that shapes everything that follows. Right now, our statutes leave a few gaps. House Bill 418 closes those gaps. We're going to hear a little bit about that more. What it does, it protects the non-offending parent. It puts guardrails on reunification orders. It requires courts to treat repeat domestic violence as a presumptive bar to unsupervised visitation in custody. And it holds accountable those who weaponize false abuse allegations in custody proceedings. I'll let my two colleagues walk through the specifics, but the principle is simple. Children are safest with a parent who keeps them safe, and our laws should say it so clearly. I urge a favorable vote, and I'm happy to answer any questions after the testimony. Thank you, Madam Chairwoman.
Thank you, Chairwoman Heverin and committee members for hearing this bill today. Again, my name is Meg Savage, and I'm Chief Legal Officer for Zero V, which is the coalition representing the state's 15 regional domestic violence shelters who collectively served over 14,000 survivors of domestic violence and their children in fiscal year 2025. I'd like to first thank Representative Nemes for working with us to bring this important piece of legislation to you. And I would also like to thank Representative Dietz for her input and real-world insight on this bill. At its core, House Bill 418 strengthens our child custody laws to ensure a child's welfare and safety are always front and center in any custody proceeding. House Bill 418 protects children when there has been violence in the home and the parents are in the process of separating. In many families where domestic violence is happening, the child has also been abused or is at high risk of abuse, even after the parents separate. House Bill 418 installs guardrails for the courts to ensure that the safety and welfare of children are the top consideration in all custody orders. House Bill 418 will require the court to look first and foremost at the violence that has happened within the family and determine how it has and will impact the child going forward. Following that review, the court will still look at other factors when deciding on custody. Recognizing that repeated violence in the home should be addressed, House Bill 418 will require a parent who has committed 2 or more acts of domestic violence against the other party, as determined by the court, to complete parenting classes, better intervention classes, or other recommended treatment prior to having unsupervised visitation or custodial rights. This seeks to ensure the child will not be further exposed to domestic violence in the home, while providing an opportunity for the parent to take steps to show that they are changing their behavior and can be a safe place for the child. The bill also requires paid supervised visitation providers and parenting coordinators to have appropriate training and clarifies that people seeking a protective order have access to a victim advocate during their hearing, as is their right in the Crime Victims' Bill of Rights. I'd now like to turn this over to Darlene Thomas, the Executive Director of Greenhouse 17, to talk a little bit about what she and her staff see as boots on the ground service providers working with survivor parents going through the family law process.
Thank you, Chair Heverin. Members of the committee, again, I'm Darlene Thomas, and I serve as the Executive Director of Greenhouse 17. And for over 30 years, I have worked alongside survivors of domestic violence and their children. I am here today to respectfully ask for your support of House Bill 418, specifically the provision requiring domestic violence training for parenting coordinators and private supervised visitation providers. This legislation is fundamentally about safety. Domestic violence is not simply high conflict. It is not a mutual dispute. It is a pattern of coercive control and a pattern that often escalates after separation. The period following separation is widely recognized in our field as one of the most dangerous times for victims and their children. When courts appoint parenting coordinators or order supervised visitation, those professionals step into cases where risk may already be elevated. Without specialized training, even well-intentioned providers can unintentionally increase danger for the families that they are trying to help. Allow me to give a few examples. In one case, a parenting coordinator encouraged frequent direct communication between the parents to improve co-parenting. What was not recognized was that the abusive partner had a history of stalking behaviors and subtle threats. The required communication became a vehicle for continued harassment. When the protective parent attempted to limit the contact, they were labeled as uncooperative. What appeared to be resistive was, in reality, self-protection for themselves and the children. In another case, a child arrived at supervised visitation visibly distressed, stomach aches, clinging to the safe parent, refusing to enter the room. Without trauma-informed domestic violence training, this behavior was interpreted as coaching. With proper training, providers understand that children exposed to coercive control often exhibit trauma responses. The child was not being coached. The child was genuinely afraid based on their prior experiences. As we know, the stakes can even be higher. In Hazard, Kentucky, a custody exchange turned deadly when a parent opened fire during the return of a child after visitation, killing multiple family members, including the mother. That tragedy underscores what can happen when separation, access, and unresolved violence intersect without adequate safeguards.
I've got a motion on the bill as amended by the committee substitute. Is Representative Stalker, were your questions answered as they were doing their presentation? Okay. Representative Stalker.
Thank you so much for bringing this bill before us. I think there is a great need for this, so I appreciate the light that you're shining on this. The question that I have is minor but important. So there was two aspects that I'm wondering if we have a fiscal note on this. So we have additional training, and we also have payment for supervised visitations, which I think are really important for both of those pieces. to be in there. I'm just wondering what the fiscal note is on that.
There hasn't been a fiscal note.
Okay, thank you.
Representative Bojanowski.
Madam Chairwoman, can Meg answer that question as well? Sorry.
Yes.
I'd just like to also say that Zero V is the State Domestic Violence Coalition, which provides training to many different types of professionals, stands ready to be a resource for that training, for the paid supervised visitation providers. And we're only talking about those individuals who are actually holding themselves out as I will supervise your visitation for payment. And as far as the other piece, what was the other piece that you asked about?
So there was the payment for visitations to supervise those visitations, but also I wasn't sure if there was going to be an additional cost for training of the GALs for those specific cases, but it sounds like that's something that you guys are already providing and there won't be an additional expense.
That we can provide that training, we can help provide that training, we can be a resource for that training. And as far as the paid supervision, you know, probably in most of Kentucky, most supervised visitation is unpaid, which is unfortunate, but there just is no capacity to provide, you know, visitation exchange centers, et cetera. So in those situations, this bill is not going to affect those individuals. That will still probably carry on, but we just want to make sure that people who are, you know, making a living off of or, you know, collecting some money to do this supervision get the training that they need.
Thank you.
Representative Dietz. Sorry, no, Representative Bojanowski.
That's what I thought.
Yeah,
I was
sorry.
paused. It's all good.
It's
Thank you.
early on a Thursday morning. Long week.
And it's early and it's raining. So I have on my bookshelf at home the book The Batterer as a Parent by Lundy Bancroft. And this is not my area expertise, but I know that there are dynamics in families with domestic violence that go beyond just that violence that is observable. Controlling behaviors, using the children as pawns in the situation. My question is, in the bill, it states specifically that you have to have 2 occasions of domestic violence, and I'm just wondering why that wouldn't be 1.
So, as you have stated, there are patterns within families, and we proposed 2 because that would clearly indicate to the court that that is a pattern that's going on in this family. It's not an isolated incident, and the dynamics that you are seeing should be enough that they can create that picture for the court. The presumption arises when there has been at least 2 incidents, but that doesn't prevent a court from looking at a single, especially a severe incidence of domestic violence and still saying the person who perpetrated the violence cannot have custody and cannot have unsupervised visitation.
Representative Dietz.
Thank you, Madam Chair. Just to make a comment. First, to follow up on Meg Savage's on the payment of the supervised visits, typically that's, in my experience, private pay. So if it's one of the parents that's requiring the supervision, a lot of times it's that parent that is responsible for the payment. And then just 2 quick comments. You mentioned coercive control. This is something I've worked on for 2 years. I wish we were at that place. I wish that we could talk about the pattern of behavior that rises and escalates before the physical act of violence occurs. But unfortunately, we're just not there yet where we can codify those terms. But I appreciate that you all use those terms because it is a pattern of behavior that escalates. I appreciate Representative Nemes letting me to work on this. This is something near and dear to my heart. There's so much more work we can do on reunification therapy, on those therapists, those trainings, and especially supervised visits. We just don't have the facilities to do that. So I know in our area we have one facility that has a very lengthy list to get on for supervised visits. So just thank you, and thank you all for the work that you do.
And thank you, Representative Dietz, for making this bill better and working with us. I didn't let you; I needed you. So thank you for that.
Thank you. Thank you all for your testimony today. And thank you, Representative Demas, for taking time to address some of my issues. But I wanted to specifically ask about the two incident. I know we've touched on that already. I know there are, when we use the word pattern, I've run across so many individuals, and I appreciate your work, all the years that you've done this, because just the brief time that I've been involved, I mean, it's just heart-wrenching. I don't know how you do it for so many years, but so I appreciate that, and all who are involved. So many times there's, unfortunately, misunderstandings. I mean, I know we're talking about violence here, but there are altercations, both parties are involved, and only one ends up being accused. I'm hesitant about the two incident. I mean, I know one incident is too much, especially, again, if it is a violent offense. But to just say two and not be very specific about what those incidents look like, and to just say that it may be a pattern versus, a low level or a situational event. Yeah, I'm a little bit nervous about that. So I would love to know why you landed. You've explained why you landed on two, but I wonder why none of the other factors or the severity of the offenses were mentioned.
Meg, before you answer, I do want to note, if I could, point the committee's attention to page 1, line 11. In the incidents that you talked about, Representative Callaway, it would require the court to find that the non-offending party is also not abusive. It is the committee sub. I'm sorry. So if both are involved in the conduct, that's something the court is directed to take into account. So, and that's something that you mentioned. I just wanted to point the committee's attention to that. Sorry.
So, I don't know if everybody has a clear understanding of what domestic violence and abuse is as defined under Kentucky law. So I think lawyers do, maybe non-lawyers don't. And so in this bill, that term is not just being bandied about as a layperson's interpretation of what is domestic violence and abuse, because that can mean a lot of different things to a lot of different people. So under our protective order statutes, we have that definition, and that's what's referenced in this bill in our custody statutes. And actually in Kentucky, in order to get a protective order, the behavior of the party is criminal behavior, because it's all tied to our criminal code. So in order to get a protective order, there has to be physical injury, serious physical injury, assault, sexual assault, which is rape, sodomy, or sexual abuse, or incest, strangulation, or stalking, or placing someone in fear that they're imminently going to be hurt in one of those ways, which is actually the crime of menacing. And so I understand your concern about, are we talking about families where there's just people fussing at one another, somebody called someone a bad name, those types of situations, right? And I think that the language in the bill is sufficient to protect against that, because the court sitting on the custody matter would have to make a finding by a preponderance of the evidence that one of the parents had engaged in criminal behavior. Now, it might not have been charged as a crime. The other parent may not even have sought a protective order for that. But the behavior itself is actually tied to our criminal code. And then the second part of your question, which is, why doesn't this bill include something about the severity or the context of the violence? And our position is that it's really, really difficult to capture that in a statute, because violence in a family can look so very different. I could give you 100 examples, having practiced family law for many years, of situations where the violence took place early in the relationship, and that was enough. because then the survivor knew, like, that look, that whatever it is the abusive partner was going to say, like, that was enough to clue them in, is like, you're about ready to get walloped if you don't do what I say or want. And in other situations, you know, you may have a relationship where the person's been controlling in some way or another, but then all of a sudden there's an explosive incident and somebody really gets seriously injured. So, you know, violence is very contextual. And the way this bill will address this is creating a presumption up front. Hey, if there have been 2 incidences where one of the parents has chosen to engage in this criminal behavior and bring violence into this family, we're going to create this presumption that they shouldn't have custodial rights or unsupervised visitation until they do the work to show that they're serious about changing their behavior. But it's just a presumption, it's rebuttable. And so, you know, that person's attorney is entirely entitled to present to the court what you're talking about, Representative Callaway. Like, well, really, here's all that happened in this incident. And so then the judge has the capacity to say, okay, I don't think that the presumption needs to apply in this particular case, and we're going to go right back to, you know, there is no presumption that you're not going to have custody. So I do think that the way the bill is framed, that will address those concerns.
Okay, we have a motion on the bill as amended by House Committee Substitute 1 and a second. Oh, we need a second. We've got a second by Representative Stalker. DJ, please call the roll.
Representative Bojanowski,
Yes.
Representative Callaway,
Aye.
Representative Kleins,
Yes.
Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Duvall,
Yes.
Representative Elliott, Representative Holloway, Representative Mosier,
Yes.
Representative Pollock,
Aye.
Representative Rayburn, Representative Riley, Representative Rourke,
Yes.
Representative Stalker,
Yes.
Vice Chair Wilson,
Aye.
Chair Heverin.
Yes. The bill passes 14-0 and should do so with favorable expression on the House floor. Thank you all so much for your work, and welcome to welcome Representative Nemes to Family and Children Committee.
Thank you, Madam Chairwoman.
Okay, I think we're going to go out of order. Representative Dietz, if you want to go ahead and make your way to the table. We're going to do House Bill 611 first, an act relating to domestic relations. Once you get settled, if you will please introduce yourself for the record.
Good morning, Madam Chair, members of the committee. Stephanie Dietz. I represent the 65th District.
Good morning. I'm Olivia Spradlin. I'm with Zero V.
Thank you all. We do have a committee sub on House Bill 611. Do I have a motion to adopt the proposed committee substitute? We've got a motion.
Second.
And a second, a motion by Representative Mosier, a second by Representative Pollock. All in favor say aye. Aye. Any opposed? The committee sub is adopted. Representative Dietz, please continue.
Okay, thank you. I'll talk about the committee sub and the entire bill together. The committee sub came to be from Representative Cook and from his district, and some concerns that they had. So Section 1 of the bill creates parity for victims of felony assaults, sexual offenses, and stalking. It creates a 10-year interpersonal protective order upon conviction for assault first and second degree when the perpetrator and victim are family members, members of an unmarried couple, or were in a dating relationship. The conviction serves as a petition and sufficient evidence for an IPO that can last up to 10 years and can be renewed in 10-year increments. The court issuing the judgment of conviction can enter the protective order. This 10-year IPO upon conviction is already available to stalking and sexual assault survivors. By extending this option to domestic and dating violence survivors, HB 611 recognizes the serious nature of these crimes and expands an important tool to help keep all survivors safe. The rest of the bill makes some changes to reporting. And I think, if I'm not mistaken, I think Senator Westerfield was originally on this, and I've run a couple of bills. The changes include updating the agencies that receive the DV data report to include AOC and the AG's office. Changes calls for service to data collected on the JC3 form to align with practice and correct data source. It creates a new data component regarding legal representation for parties in protective order hearings and updates the data component for the cabinet regarding child dependency, neglect, and abuse and family violence. All important information so that we can continue to track these cases. Would you like to add anything?
Just thank you to Rep Dietz for working with us on this. We're here in support of the committee sub.
Representative Bojanowski,
Yes.
Representative Callaway,
Aye.
Representative Klein's,
Yes.
Representative Dietz,
Yes.
Representative Doan,
Aye.
Representative Duval,
Yes.
Representative Elliott, Representative Holloway, Representative Mosier,
Yes.
Representative Pollock,
Aye.
Representative Rayburn, Representative Riley, Representative Stalker,
Yes.
Representative Rourks,
Yes.
Vice Chair Wilson, Chair Heverin.
Yes. The bill passes with favorable expression, 14 yeses and 0 nos, and should do so on the House floor. Thank you all for your presentation, and Representative Dietz, if you will continue to stay at the table. The next bill we will hear today is House Bill 598, which is an act relating to guardian ad litem and other appointed counsel. You have already introduced yourself for the record. Do you have any guests with you today?
I don't know if Miss Moody wants to come up and sit.
All right. If you will introduce yourself for the record,
Shannon Moody, Kentucky Youth Advocates.
and then you all can go ahead and get started. We do have a House Committee substitute on House Bill 598. Do I have a motion to adopt the proposed House Committee substitute? We've got a motion by Representative Callaway and a second by Representative Mosier. All in favor say aye. Aye. Any opposed? All right. The committee sub is adopted. Please go ahead and get started.
All right. Again, thank you, Madam Chair and members of the committee. First, I'd like to say a few things just about the bill in general. This is something I have thought about for probably a decade. I've been practicing family law for 32 years, and early in my career, I did serve as a guardian ad litem probably for about 2 or 3 years. And I would say back then, the max fee that you received was $250. Subsequent to that, this legislature has raised that fee to $500. It's also my observation that we probably have more cases involving guardian ad litems at this point than when I initially started. So a guardian ad litem is an attorney that represents children in cases, and this bill talks about guardian ad litems, but it also talks about court-appointed counsel, which are attorneys that are appointed to represent the parents, typically in dependency, neglect, and abuse cases. What I also will let you know is while we were working on this bill, and I would be remiss if I didn't thank Eric with the LRC staff for all of his hard work in the interim on this bill, there are about 20 different places in our statutes where we talk about guardian ad litems. And just this session, I've had people ask me to review their bills, and in it, it'll say, and they will receive a guardian ad litem. That's a fee that we pay as a state, first of all. If you look at our budget that in House Bill 500 right now, I think it's $12 million per annum, which is in there. I got the statistics, and for fiscal year 2024, it was in excess of $14 million that we paid out for guardian ad litem and court-appointed counsel. So now, with that background, what does House Bill 598 do? House Bill 598 is going to be known as the Family Representation and Advocacy Act. It establishes the Department of Family Representation and Advocacy under the Justice and Public Safety Cabinet to provide a state-sponsored and controlled system for training and appointing guardian ad litems and other counsel. The organizational structure will have a commission, and then the commission will have a director. The director will have 7 regional managers. When we initially started this, we talked about doing it under the cabinet divisions. We went back and instead now we have it under the Supreme Court districts. The director is supported by and may be accountable to a newly established commission to be known as the Family Representation and Advocacy Commission. The commission is comprised of 9 voting members and have specialized professional or personal experience that is relevant to the work of the department. House Bill 598 offers a flexible approach to ensure clients are matched with the appropriate services. Specifically, while House Bill 598 provides that the department may hire staff attorneys to provide legal representation to legal clients, it allows for the director to enter into contracts with private attorneys, law firms, nonprofit legal service programs, and law school clinics as necessary to ensure the delivery of high-quality legal representation. Further, House Bill 598 recognizes the value that a multidisciplined approach can have to serving some of the Commonwealth's most vulnerable populations. As the bill provides that the department may hire or enter into contracts with professionals like social workers who offer important complementary services like targeted case management. So far, what we have is 22 other states have relied on state-sponsored and controlled systems to provide legal representation to children and adults in child protection cases. We looked specifically at Oklahoma and New Mexico. There are other states that I'm happy to share that information with you. I can go into all of the specifics, but I think at this time I'd like to turn it over to Ms. Moody to talk about what took place during the interim and a study that they did.
Thanks, Representative Dietz. So over the interim, we have gathered judges, administrative office of the courts members, Department for Community-Based Services, and then importantly, youth with foster care experience and birth parents who have child welfare system experience to weigh in on what is needed from their legal representation within the system and where right now we are seeing inadequate legal representation in some communities. We have fantastic, incredible, zealous advocates across the Commonwealth, and then we also have, unfortunately, representation that delays cases, creates lack of access to resources for kids and parents, and also creates delays that cause children to linger in foster care. So over the interim, we worked to identify different state models that identified and adhered to what the core of that group was looking for related to accountability, compensation, support, and structure that would really create a system in Kentucky that provides quality legal representation to every kid in the foster care system and for those parents who cannot afford court-appointed counsel. One of the studies that we, in partnership with the Administrative Office of the Courts, did was engaged family court judges and district court judges who serve on DNA cases to identify and understand a lack of legal representation. 2 out of 3 judges identified that they have lost attorneys from their counties as a result of high caseloads, low compensation, or lack of support within the structure. So with that, we engaged Representative Dietz. We've engaged other members of the legislature to talk about a real need for reform and some critical steps to ensure that we don't continue to lose really high quality attorneys who are serving in this space, and there's still a potential to recruit and retain attorneys in the future so that we have adequate representation for all kids in the child welfare system and their parents.
I think what I would like to conclude with before there's any questions, I'm not going to pretend like this is is perfect and everybody's happy with it. There was a lot during the interim that we did work on, and right before the bill was filed, there were some concerns that I received from several judges, and the concern I heard is that they may lose control over who's appearing in front of them, and that they're best suited to decide who's the most qualified to appear in front of them. And while I understand that, and I also understand that change is hard, and would remind people that we didn't have family court when I started practicing, but we do now, and that came as a result of a pilot project. We don't allow judges to pick who the public defender is that appears in front of them. We don't allow the judges to pick who the county attorney is that's in front of them, and they can't tell a private attorney, you can't appear in front of me. So I think this is going to be helpful to the judges. It'll be the department that is appointed, and then they will pick qualified attorneys. This is not going to change, in my opinion, what the attorneys do. They will just be getting their appointment from an office. This was not set up to make sure that attorneys couldn't have a private practice. We left this pretty open so that the departments could look at what the needs are. After lots of discussion on this bill, I'm committed, if we get this out of the House and over to the Senate, I would like to see this as a pilot project where we would use maybe an urban area, someplace maybe in northern Kentucky, with a bigger area, a rural area, and maybe an area that doesn't have family court, where we just have district and circuit court. And I've made that commitment, and I will follow through with that in discussions on the Senate side. But I think this is very much needed, and I would appreciate your all's vote on this bill.
Madam Chair, motion on the bill, amended by the committee sub.
Okay, we've got Representative Pollock. He's going to be the member of the week. We've got a motion and a second on the bill. We do have one person, Mr. Nick Caprino. If you will come to the table from the Children's Law Center. I do want to remind the committee, we have about 22 minutes before we need to be out of this room. So please be clear and concise with your questions. I know this is a really big bill, but because we have a motion and a second, Nick, if you will share what you need to, we'll open it up to questions. And if you'll turn on your microphone, please.
Thank you. Is that better?
Yeah.
Okay,
Thank you.
great. Thanks. Again, thank you, Chair Heverin, Vice Chair Wilson, the committee for the opportunity to provide testimony on House Bill 598. I want to thank Representative Dietz for bringing this important legislation and thank the committee for its leadership for families and children in Kentucky. My name is Nick Caprino. I'm the Deputy Director of the Children's Law Center. CLC is a nonprofit law firm that's protected the rights and safety of kids across the Commonwealth for 37 years. Each year from our offices in Lexington and Covington, we represent over 500 youth, and we provide legal education to over 1,000 individuals that include lawyers, judges, social service professionals, and education providers. We frequently serve as guardians ad litem in cases where children are victims of crime, parties in protection order cases, and in dependency, neglect, and abuse cases, DNA cases. In addition to representing children in court, my colleagues and I have trained hundreds of lawyers and other legal professionals on how to strengthen the quality of representation for kids in Kentucky. These experiences have given us a front row seat to what works and what doesn't when representing kids and all parties in these cases. What we know without question is that the quality of representation for every party matters enormously. House Bill 598 takes an important step toward ensuring and enhancing that quality. In DNA cases, for one example, everyone in the courtroom is searching for the same answer. What outcome is the best interest of the child? And the answer to this question can be extremely difficult to find. These cases often are complicated, emotionally charged, and heartbreaking. To do our work well, GALs need more than goodwill and compassion. We need structure, training, mentorship, resources, and oversight and accountability. Right now, that structure largely doesn't exist. GAL availability varies vastly by county. There's no statewide standards for caseloads. Judge manage GAL shortages and turnover court by court. We know that when attorneys are not adequately supported or held accountable, courts are forced to make high-stakes decisions with less information than they need. Moreover, coordination is especially critical because children's cases often span multiple court systems. At CLC, we regularly represent kids in multiple different court settings, the child welfare setting and justice settings, and we see the inefficiency and confusion that comes from lack of coordination between cases. The same child may have multiple attorneys in multiple courtrooms, each requiring that child to retell the painful and emotional and traumatic experiences again and again. A unified structure increases the likelihood that that child has one well-supported, well-trained guardian ad litem across all related proceedings. For all of these reasons, we need a better path forward, ensuring quality representation, accountability, and efficient use of public resources. Coordinating a network of guardians ad litem will improve Kentucky's outcomes for children, support courts and attorneys, and ensure taxpayer dollars are used efficiently. House Bill 598 can help do that. On behalf of CLC, I urge you to pass House Bill 598. Every day, Kentucky children are sitting in courtrooms waiting for a legal system to decide their future. Those children and their families deserve attorneys who are trained, supported, and empowered to meet an appropriate standard of practice. Finally, I want to express gratitude to the Kentucky General Assembly. We deeply appreciate the continued support for the Children's Law Center so attorneys like me can continue to provide vital legal services to vulnerable kids in Kentucky. Thank you.
Thank you all. Okay, we've got some questions from the committee. Representative Stalker.
Thank you so much, Chair Heverin. My question is actually for Representative Dietz. So what I understand that this bill is trying to I understand what this bill is trying to accomplish, and I think there's a lot of work that you're going after that's really important that needs to happen. And I know change is hard, and I have had several conversations with GALs in Jefferson County, which we are our own kind of animal with 10 family courts, as well as some family judges as well. So I think because we're in a budget year, I have to ask, what is going to be the cost of creating this department, so to speak, and how will we as a state pay for that?
So thank you for that question. So I did ask for a fiscal impact statement, and their fiscal impact statement they were able to provide just to set up the commission. So the GAL fees, that's just going to be a shift. So it's just going to go from directly being paid to the attorney. So I don't see an increase in those fees at this time. But to set up the commission, what they anticipated was $3 million. What I will also say is in the bill, we have directed the cabinet to draw down on 4E money. This is something that we have been trying to get information on. And this morning I took a moment and I printed off an email that I sent, and then also one from our staff from Brad Montel asking if we could get this information from the cabinet. This was sent back in December. We've yet to receive that information. I believe I've got the information here. We're one of only a handful of states that does not take advantage of drawing down 4E money that is specifically there so that we can assist paying attorneys for children in the child welfare system. So this directs the cabinet to draw down on that 4E money. What I'm hoping, and one reason we did not include an increase in fees, because we also ask that they, over the next 2 years, look at a study or look at how we're paying guardian ad litems. Right now, the cap is $500. Is it on an hourly basis? Do we do it by type of case? Do we do it by how long the case lasts? I don't know. There didn't seem a way to say, just let's raise it $100. Let's raise it 3%. There was nothing to base that on. What I'm hoping is that we see that 4E money come in, and then we've got more dollars to work with, and then we have more information to know what should a guardian ad litem be paid.
May I ask a follow-up question, please, quickly? Thank you. And thank you for the information you just shared. I'm concerned that we could be drawing down federal money that would help support our GALs and our kids that are in the courts, and we're not doing that. So I'll be following up with you and some others on that to find out why we're not doing that. My other question is something that was brought up to me from other GLs that was not in my purview of understanding, was a conflict of interest. So we wouldn't have two attorneys from the same firm or company representing members of the same family because of there being a conflict of interest. So how do you anticipate us addressing that?
And we talked about this last night. Representative Stalker and I had a long conversation last night. There's other organizations that run into that same problem. Legal Aid of the Bluegrass is one I can think of. I'm sure the Children's Law Center runs into that problem. But we've given each of these departments the ability to do contract attorneys. I anticipate that there's going to be a lot of attorneys that choose to be contract attorneys and not an employee. And so I think that alleviates the concern that there's going to be a conflict.
Thank you.
Thank you. Representative Rorks.
Thank you, Chairwoman. Representative Dietz, I want to just acknowledge that I think we agree on the goals of that this bill is trying to accomplish, and it's a work in progress, and there might be this ability for it to be a pilot so we can test it somewhere. Because as we know, many of the jurisdictions in the state are very different from each other, and over the last 48 hours, I've gotten to hear from a lot of different places, but especially from our Jefferson County GALs and their concerns. And I'm not sure that they're fully addressed at this time, so that's causing me some hesitancy today. One of the things that they brought up is about is it realistic for them to need to be able to travel across counties, especially with the kind of the geographic landscape of our state, how much of their time is going to have to be spent just commuting from one place to another, and then also potentially having to be kind of constantly available and ready to take a case at any given time. Can you respond to those concerns?
Yes. So first I'll talk about the concern that they're going to have to drive across counties. While there are regional offices, I would rely on those managers, and they're going to look at where those attorneys are located. I just don't see that this is going to change that much, that if you are an attorney that practices as a guardian ad litem in Kenton County, the manager would still assign you to Kenton County. I will speak to, Representative Petrie, which I know lives in a rural area and handles, I think, the guardianship GALs in Todd County. I don't know that that's going to change, and he would still do those. I don't think he would need to accept an appointment 3 or 4 counties away. So I don't think that that's a real concern. Second, I think your question was
about trying to have to be available.
To be available. Right now, I can tell you in our counties, we know what days the DNA dockets are. If there's an emergency, I don't think it's any different. The court staff would inform the department, and they would reach out to an attorney to see if they're available for the emergency, but otherwise they know what day the DNA dockets are. They're always held. Each division has a specific day that they hold DNA court. In our area, and Nick may know more, I think we have one judge that allots maybe 3 days a week. We have one judge that does 1 day a week. So every judge is unique in how they handle those DNA dockets. But I would say that if you are an attorney representing children, you know what day of the week that they're handling the DNA docket, just like there's a different day they handle EPOs.
Right. Chairman, can I ask a follow-up?
Yes, one more quickly, please.
Thank you. Just without those, especially the folks from Jefferson County being able to be here today and just answer some of these questions. I don't practice law, not my area of expertise, but I definitely want to elevate those concerns that this is still a work in progress. As it moves through the process, I hope that they can weigh in a little bit more and make some things better. And if a pilot is the future, I think being able to test this is a good approach moving forward. But I think there's still some concerns, especially around the ultimate goal that we want to get to is solving this pay issue. And I know that we're going to study it, but I wish that there was a little bit more to happen today around that issue, since these folks are doing a tremendous job on a very small amount of wages.
And I absolutely agree with that, and I wish I would have gotten the answer from the cabinet on why we're not drawing down on the 4E funds.
It seems that we always have issues with drawing down on 4E funds here at Families and Children. There are no more questions. Before I call a vote, I do want to say a few things. Representative Dietz, thank you so much. It is really hard to come and change something in government. And, you know, I've received a lot of emails over the last 24 hours since I've called this bill. And the one thing I've learned is not one person is concerned about, is this best for children? They're all concerned about if it's best for the adults. And I'm really sad about that because I feel like every bill I bring into my committee helps children. And we've had a lot of long conversations and something I want to start working on. And I think you'll see a concurrent resolution come through here next week is we're missing the part of court, everything in between the child being removed and the problems that start to the adoption. And we've got to start looking at that with guardian ad litems and friends of the court. And because at the end of the day, it's what's best for kids and what's going to help them, because that's all we're all here to serve. And I actually spent time in family court. I've spent time in family court and district court. I felt like that was really important last summer. And with that, answer Representative Rourke's question, there was a guardian ad litem that was in Hardin County. He was also in Grayson County, and he was from neither of those counties. And so I think that's already something that guardian ad litems are doing or driving across county lines, especially in rural Kentucky. That's going to be part of it. We've got a real issue in Jefferson County Family Court right now. I don't want to specifically just call them out. We've got problems everywhere. And until we start making kids a better life, we're failing all of them. And so I appreciate, even though this might hurt and be painful, I'm sure whenever family court was introduced, it was hard and painful, and look at the good it's done. And now it's time for us to reevaluate what that looks like and see, okay, what can we do to better serve kids? At this time, because we have a motion and a second, I am going to call a vote. DJ, please call the roll.
Representative Bojanowski.
Yes, I'd like to briefly explain my vote. Yes. So I'm going to pass today. And I did speak with Representative Dietz. This is a very new topic for me. But I've gotten some communication from an attorney in Louisville, and I just want to make sure that her concerns are addressed and I understand them fully. And very much her concerns are what is best for the child. So thank you.
Representative Callaway.
Briefly explain my vote. Thank you. Thank you, Representative Dietz, for your hard work on this. I really appreciate you taking the time to talk out some of my concerns. I'm glad we're moving toward a pilot program so some of this can be hashed out and we can figure out the best approach. I, too, have received nonstop emails about this, and I second the fact that I didn't see a whole lot of mention of the kids, and it was disheartening. And I think you did an excellent job addressing the concerns that I was reading, that I did take the time to read through, or have the time to read through. So thank you for your diligence on this, and I look forward to seeing how this plays out. And I'm an aye, obviously.
Representative Kleins.
Explain my vote, please. I'm a yes. I would just like to say in working with Representative Diltz, when she tackles a bill, she's very pragmatic, thoughtful, and I'm sorry. I said Diltz? Oh, Representative Dietz. Sorry about that. I do know some Diltzes. So I think she's very pragmatic, thoughtful, and intentional. And I appreciate her courage and conviction. So thank you. Yes.
Representative Dietz.
Yes.
Representative Doan.
Yes.
Representative Duval.
Yes.
Representative Elliott. Representative Holloway. Representative Mosier.
Explain my vote. Thank you. Thanks for your work on this. This is, I think, very strong work, and moving toward the pilot, I think, will give those who I have heard from some comfort in our ability to study this issue. So thanks for your work. I am a yes.
Representative Pollock.
Aye.
Representative Rayburn. Representative Riley.
Yes.
Representative Rourks.
And briefly explain my vote.
Yes.
Thank you. I'm going to be a no today. I acknowledge that this is a work in progress and that tremendous work has been put into it. But I do want to just reflect what the concerns that I have heard from the public, and then also want to acknowledge that these are our guardian ad litems are the folks that take care of our most vulnerable children. And we need to make sure that we're getting this right for them, because if they don't have what they need to be able to do the work, then they're not going to be there. And so that's something I just, for the most vulnerable children. And so I think that's something that needs to be reflected. So I'm going to be a no today, but I'm looking forward to see how this bill evolves. Thank you.
Representative Stalker.
Explain my vote, please. I'm going to be, thanks, that's okay. I'm going to be a pass today, and for one reason only. I need to have deeper conversations with our family court judges in Jefferson County. I think one of the largest concerns that they have, and something that I'm also concerned about, but I think in conversations with you previously, and I'd love for you to be able to talk more about this at a later date, is how do we not lose the expertise that our family court judges have in knowing those GALs and making very thoughtful appointments. So that might mean a situation where they know a GAL has more experience in working with kids who have been victims of sexual abuse, for example, or kids with different identity issues. Somebody, especially for a female child victim, maybe not wanting to be partnered with a male GAL, things of that nature. So I think there's probably ways that we can work that out, and I think there needs to be some more conversations with our family court judges to put them at ease, so that they know that should this go through, that the kids and that their GALs all will be in good hands with whoever is going to be making those appointments. Thank you.
Vice Chair Wilson.
Briefly explain. I get appointed to quite a bit of these, so I reached out to ethics to see if I should abstain or not. I've not received an answer yet, so as of now, I'll abstain due to Section 57 of the Constitution. Hopefully I get that answer before it comes to the floor. Thank you.
Chair Heverin.
Yes, and I will briefly explain my vote. There are some good guardian ad litems doing a good job. So I don't want a meme on Facebook saying Chairwoman Heverin hates GALs. That's not the case. I want to bring people to the table and really have these conversations. And at the end of the day, to my point, I want to make sure we're all doing right by our kids, because they are our future. So I proudly vote yes today. The bill passes with favorable expression with 10 yes votes, 1 no vote, 2 passes, and 1 abstention. Congratulations. And I will take a motion to adjourn.